Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. All right, I'm here with University of Waterloo's Emmett Macfarlane, and some of you may have seen the absolute histrionics over this federal factum to the Supreme Court on the challenge to Quebec's Law 21 on secularism. Air quotes, very much needed. So I think, first of all, I think we need to establish that this is a factum. This is not a reference question. The way people have been describing this has been more to the latter. Emmett, I'm going to get you to explain the difference between the two for our audience.
Yeah, I mean, in any constitutional case, the Supreme Court will allow applications for interveners. In the case of governments, in constitutional cases, it's automatic. And so this is not the government as the litigant. It's not the government creating the hearing by posing a reference question. Is the government of Canada and indeed some of the provinces also getting a say in the proceedings around litigation that is otherwise happening with people who have brought a constitutional challenge to the court. And so the government, I mean, in terms of submitting a factum or a set of arguments for this is completely normal.
Yeah, and I think the other thing to mention is that a lot of cases for an intervener, they won't take a position on the actual question, but they just want to have a say on a piece of law that this is touching on, and that's I know I've seen some people say, how can the government not take a position in this case? But and my understanding, having covered the Supreme Court for 12 years or so, is that in most cases, interveners are not taking a position on the actual question. It's the point of law that they want to make a point on.
Yeah, I mean, I think the main thing the court wants is for any intervener to be contributing something somewhat novel to the proceedings, a perspective that's not being aired. It's really a service to the court to edify the court on the broader context, and sometimes it's the broader social context.
Yeah.
Sometimes it's not even narrowly about a question of law so much as what the interveners want to bring. That said, interveners often make it known what they feel about the central question that's before the court. There was nothing really prohibiting the federal government from making a clear statement that the bill is blatantly unconstitutional. And the only reason I say that is because it actually informs part of the context around this debate over the use of the notwithstanding clause. And we have to be a little bit realistic. And to the extent that some of this, and one of the many arguments the court is going to be dealing with, will surround preemptive use of the notwithstanding clause.
Yeah.
That fact really is a bit of a clarion call that there's a constitutional defect with this legislation. And so it's a bit cowardly for the feds not to have taken a position on this, but I mean, this is long-standing, going back to Justin Trudeau's government. They really refused to properly criticize such an egregious law in this case.
All right, point taken. So the other bit of background I think that we also need in this, and I'm going to include a link in the description, is that a couple months ago, the Saskatchewan Court of Appeal was going through a similar question on the anti-trans laws in Saskatchewan, and ruled that just because the government invokes the notwithstanding clause doesn't mean that the courts can't still weigh in. And that's kind of, I think, part of what's informing the argument that the federal government is making in their factum is that, and the way the judge or the majority on the Saskatchewan Supreme Court, or sorry, Court of Appeal said was just because the government essentially they don't get the last word if they invoke the notwithstanding clause. So the court is saying that we should still be allowed to weigh in even if we can't strike the law down. And so I just want you just make sure that you're understanding that in the same way that I was.
Yeah, that's certainly how the Saskatchewan court ruled. There's a bit of an interesting difference between the trial court in Quebec and the Quebec Court of Appeal, and in the Bill 21 case on this point as well. There's an academic debate about this, although my view is most legal scholars and constitutional experts would argue that there's nothing in the notwithstanding clause that actually prevents a court from declaring or making findings about the
Yeah.
constitutionality of an act. There are, in the academic world, there are kind of these superficially sophisticated explanations of why we should read the provisions of the notwithstanding clause that deal with kind of preserving the operation of laws, notwithstanding the rights involved, why we should interpret that as ousting judicial review. Uh, these arguments are deeply flawed. And the main reason I say that is because if the intention was to oust judicial review, and I mean oust courts even having a say, indicating the constitutionality of laws, it should have to be much more explicit in the text. Nothing in the notwithstanding clause prevents a court from making a ruling, from issuing a declaration. It's what the notwithstanding clause preserves by way of parliamentary sovereignty is that the law continues to operate notwithstanding that potential unconstitutionality.
Yeah.
And so some of these defenders of the notwithstanding clause are guilty of the same thing some critics of the notwithstanding clause are guilty of, and that is they want things read into the notwithstanding clause that simply aren't there. They want the courts to basically reinterpret and basically amend the Constitution, either to kind of falsely limit the notwithstanding clause in ways that the text doesn't, or to like say the courts don't even get a say. This isn't even about whether the courts get the final say. They shouldn't even be able to rule on the issue, as if that is somehow improper rather than hugely beneficial in the context of the media, in the context of citizens knowing and getting kind of an authoritative statement that rights are being violated. The notwithstanding clause wasn't meant to hide what governments are actually doing. It's simply meant to preserve parliamentary sovereignty in relation to some rights so that government policy initiatives can still go forward. And ideally, in contexts where the courts may have gotten it wrong. Not a lot of people were envisioning all of this preemptive use of the clause to try to shut courts out of the process entirely. And so there's a bit of disingenuous argumentation going on there.
For sure. I think it's also just for people's understanding, the notwithstanding clause has a 5-year sunset on it automatically. So a government that invokes it needs to renew it every 5 years, with the theory that voters can, within those 5 years, say, no, we don't think you should get another term because you've invoked it because there was was up until a few years ago a big political anathema against it, but that's kind of fallen to the wayside. And by the courts weighing in, it's a way of informing voters that within that, or when it comes to the next election, be it provincial or federal, who's invoked it, that the voters can then weigh in.
Yeah, there's the 5-year limit is the maximum life of any legislature or parliament, and so you allow intervening elections to happen, you allow potential changes in government to happen, but the legislature needs to continuously, if they want to keep the notwithstanding clause in place, if they want to keep a law that might be invalid operating, they have to renew it. The sensible kind of limit on a rather extraordinary power. There are now, because of the federal government's very vaguely written factum about whether there are circumstances where rights are basically completely vitiated, which they argue is not what the notwithstanding clause was meant to do. There's now raised these questions. Is the federal government arguing there are somehow limits on how many times renewal can happen, or even are there such egregious uses of the notwithstanding clause that are such an affront that the court should impose some limits? And the federal government's factum is not explicit on any of this. and I think it's fair to say that there were some histrionics in reaction to the factum, but it's vague enough that you kind of wonder what exactly they're getting at. Like,
Yeah.
what do they mean when they're suggesting that there are circumstances where certain uses or repeated uses of the notwithstanding clause basically destroy a right instead of simply allowing laws to operate even though those rights continue. I don't know that anyone can read those relevant sections of the government's factum and know exactly what they're talking about, but they seem to be trying to signal something a little novel to the court in terms of that argument.
Yeah, and that was kind of one of the questions that I had when reading it, was because for the most part, it's we want just the ability of declaratory relief, that, the court can say that if you had not invoked the notwithstanding clause, this would be unconstitutional. And that's what a lot of it is, and that's why I find some of the reactions to this to be just completely out to lunch. But yeah, there was this section in there about repeated use, and I I had a hard time understanding about how this was supposed to nullify the notwithstanding clause. Um, and just also say that part of what they said in there was that this becomes a de facto amendment to the Constitution without actually going through that process. If you just keep using the notwithstanding clause over and over again.
Which is not an entirely compelling argument, because the way the notwithstanding clause is structured was precisely for the idea that, particularly some provinces during the debates of the charter were concerned that courts would make decisions that would really constrain their jurisdiction. So not just the rights issues involved, but that because the charter was in part meant to be this centralizing force, everyone across the country would have the same rights. So governments across the country would have the same limits imposed on them. This wasn't a bunch of angry premiers envisioning Danielle Smith wanting to institute anti-trans laws in her province, and we need to protect the moral sanctity of the 1982 that we're living in. Yeah. This was also like people like Alan Blakeney, progressive premiers in the provinces, who are concerned we'd see court rulings that would do things like restrain the growth of the welfare state, right? And so, yeah, the notwithstanding clause is a temporary measure by virtue of the 5-year limit and the requirement for renewals. But if you believe that there was a possibility that courts would interpret the charter in ways that would prevent economic redistribution by provinces or robust welfare state social services and programs, the notwithstanding clause would need to be continuously used to preserve those structures. So anyone thinking about the purpose of the clause needs to think about the circumstances in which it was established, and also its structure. Its text is it's actually one of the clearest constitutional provisions we have, in that it's very much about form and procedure. It identifies relatively clearly which sections do and do not apply under the charter to the notwithstanding clause. There's a debate over section 28. I think the text is clear that when it comes to equality of the sexes, the notwithstanding clause cannot apply. And so Bill 21 could be struck down on the basis that it disproportionately impacts Muslim women from that alone. But again, there's a scholarly debate over that. Yeah. So it's not perfect clarity, but on the issue of renewing, there are no limits. If anyone intended for there to be limits on how often things can be renewed, they would be in the text. And we don't always we can't always rely on the text solely as a matter of interpretation. We have to think about the context, the history, the purpose, the underlying purpose of these constitutional provisions. But on this point, it's quite clear. And so it is a bit confusing what the federal government is trying to raise here by, there are perfectly sensible elements to that factum. They emphasize the notwithstanding clause doesn't apply to all rights. That's obvious. They emphasize that they really want to drive home the point that courts can make declarations about laws, even if the notwithstanding clause applies. I think that much is clear. There are no express limits in the text.
Yeah.
But raising this idea that somehow repeated uses are akin to constitutional amendment, the implication becomes the courts could, in some contexts, impose limits. And I actually think they're the ones implicitly suggesting the courts should amend the notwithstanding clause by imposing new limits. And I just think that's dubious. If they have a different intent in mind, they should have made this much more explicit about it's a factum to the court in the context of a specific case. Be explicit about what you're asking the court to do. And this factum suffers from vagueness and ambiguity on some of that.
Okay. All right. So with that in mind, anything else about either the factum or just the outsized reaction to it that you think people should really kind of be aware of or think about?
I mean, I think there's a handful of people kind of showing their colors on this stuff. And there are, I think, from the point of constitutional law, there are silly arguments on both sides. There are people who want the court to use unwritten principles to constrain the use of the notwithstanding clause, people who want the court to revisit its decision in Ford v. Quebec on whether the notwithstanding clause can be used preemptively or it has to be in response to a court decision. Again, absent clear limitations in the text. These are dubious arguments. But the defenders of the notwithstanding clause seem to have lost the plot a little bit in reacting to criticisms of the clause that stem from really bad uses of the notwithstanding clause, right? Like any extraordinary power, we should be able to criticize its use on a case-by-case basis. And provinces have fallen into a trap in using the notwithstanding clause not to protect rights or to balance competing rights against each other, but to viciously go after certain minority rights and other rights under the Charter. Bill 21 is simply unpalatable. That doesn't mean the notwithstanding clause isn't a valid constitutional instrument. It's part of the Charter, and there are people saying it's anti-Charter, but that's nonsense. But I think the defenders of the notwithstanding clause are reacting to almost any criticism, whether it's a moral or a legal criticism, in such an overtop fashion that that they'll defend any use of the notwithstanding clause from that perspective, and that they're now trying to impose certain kind of perspectives on the notwithstanding clause that are also kind of historically wanting. The idea that the notwithstanding clause ousts judicial review. The idea that courts making declarations on laws, even if the notwithstanding clause have been applied, is somehow... I saw someone arguing, a legal scholar argue that it's actually damaging to judicial independence because the courts should stay out of this. This is purely a political instrument, not a legal instrument. It's a legislative instrument. It's an instrument, a power of the legislature, but it's illegal as much as it is a political instrument, and the courts have a role to play. The notwithstanding clause is fundamentally about contexts where the founders of the Charter believed the courts shouldn't always have the final say. No one ever talked about the courts having no say. And so there's a lot of kind of over-the-top advocacy for the notwithstanding clause, as if it would be a cardinal sin for the courts to still articulate charter standards in relation to laws, even if those laws will continue to operate. I think they're showing their colors to the extent that they don't want the public to see just how nefarious some of these uses are and should be seen, and that they should be subject to political judgment of an electorate that still respects not only the rule of law but respects the rights and particularly the rights of certain minorities that are being targeted in this era of right-wing populism.
I guess my last question would just be, I know you have mentioned in the past some legitimate uses of the notwithstanding clause, and just for the sake of the audience who thinks that we should just get rid of it, I know you've had some examples of where it's actually been kind of a useful thing to have.
Yeah, I mean, so in the 1990s, there were a couple of pretty troubling Supreme Court decisions in the area of sexual assault law regarding when can accused access the therapeutic records of sexual assault victims, and over things like the extreme intoxication defense, where the court kind of weighed a little more heavily in favor of the rights of the accused or a fair trial versus the rights of sexual assault claimants. And it would have been, Parliament responded legislatively to these things and kind of pushed back a bit against both rulings in different ways. And a lot of people argued at the time they could have used and should have used the notwithstanding clause to make it clear that the Parliament was taking the position that the courts were wrong on the balance of things and make a more emphatic statement. And that would have been a perfectly legitimate, and it would have been debatable. Like you could see arguments on both sides, but it would have been a perfectly legitimate use of the notwithstanding clause. Similarly, after the Carter decision on medical aid in dying, the government went back to the court to try to extend what's called the suspended declaration of invalidity. So the court originally gave Parliament a year to respond to its decision on the MAID law, the anti-MAID prohibition, to figure out a legislative scheme. Some people don't like that because you're basically it's basically the court suspending the charter for that period and the rights that it just found were being violated. And if Parliament needed more time, it would have been valid to use the notwithstanding clause to give itself a little more time to develop a legislative scheme. It would have been controversial again, but it would have been a valid use because it would be it would be Parliament saying we don't want a total vacuum here. We need to develop a regime. It takes time. There would have been an argument for it. And to give a final example, I'll give an example of where the notwithstanding clause was actually used, and that was Saskatchewan using it in 2017 on a case that dealt with school funding, religious denominations, and school choice. And the trial court decision that basically determined that I'm going from memory here, but I think it was basically like non-Catholic students going to Catholic school that this is actually contrary to I think the Manitoba Act or whatever it was. The government jumped in, and rather than waiting for an appeal, it used the notwithstanding clause right away. Now, we can debate whether that's appropriate. I think they should exhaust appeals before using something like that. But on the issue, in terms of defending kind of flexibility, school choice, a legitimate policy decision, where the rights, what were the rights issues really involved here in terms of the charter aspect of this context. I have no problem with a legislature kind of pushing back on a court decision that it has a very kind of coherent argument why the court got it wrong. So there are examples where perfectly legitimate and valid uses of the notwithstanding clause. I've become more of a critic of the notwithstanding clause just because in Ontario, in Quebec, and now what's being proposed in Alberta, there's such egregious attacks on minority rights. These are bad uses of the notwithstanding clause. But you can, whether you develop hypotheticals or look to real examples, there are valid uses of the instrument.
All right. Well, on that note, thanks again for taking the time to do this. This is incredibly helpful, and we'll do this again in the future.
Thanks for having me. Take care.
All right. Cheers. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. It's at Journo_Dale on Twitter and JournoDale __ on Bluesky. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.